So the Supreme Court has relisted the challenges which aim to strike down assault weapon and magazine bans nationwide once again. They've been relisted 10 plus times, but now there's another case which may impact the outcome of these challenges as well. So let's break down what is happening. Now, really quick before we jump into this video, I want to thank one of the main supporters of this channel, which is 1st Phorm. 1st Phorm's an amazing company. They have great supplements. I use their protein powder and their pre-workout every single day when I work out. I cannot recommend them enough. They taste amazing, but also the amazing thing about 1st Phorm is they're pro-America, pro-freedom, and they support the Second Amendment. I highly recommend them. You can check them out using the link down below. And if you use my link down below and you order something $50 or more, you can get a free 4-pack of energy drinks. Now, as I mentioned in the intro, in this video, we're going to be talking about some of the important developments in a couple of the cases which are challenging various state bans on so-called assault weapons and then their magazine restrictions as well. Now, these critical cases we're going to be breaking down. Many of you are familiar with them. We've been tracking them, and they're currently in front of the Supreme Court. They're the Snope versus Brown case, and then also the Ocean State Tactical case. Unfortunately, as of right now, the Supreme Court has not granted review to either of these cases. They continue to get relisted, and at this point, they've reached such a high number of relists that a lot of us suspect that something interesting is actually going on with these. And also, maybe there's another case which currently is going to get to the Supreme Court, which is the Duncan versus Bonta California magazine ban case. That case could actually also tie into these other challenges as well. So we need to talk about what this implicates, what this signals, and how the Duncan case could change the outcome of these cases and potentially what could happen to them going forward until Duncan gets to the Supreme Court. Now, for those not aware, the Snope case is kind of the biggest case out of the two currently in front of the Supreme Court because it deals with a state's ban on so-called assault weapons, and it was prior GVR, meaning that it was granted, vacated, and remanded by the Supreme Court back down to the lower court in light of their decision in Bruin. This case involves the state of Maryland defining certain firearms as so-called assault weapons and therefore banning them within the state. This ban was challenged in a Maryland federal district court. However, the case was then dismissed by that lower court because there was already some precedent on the books there prior to Bruin that said that this type of statewide ban was permissible. So in 2022, this case, Snope, prior known as Bianchi, made its way to the Supreme Court, but after they issued their Bruin decision, this case, Snope, was then GVR'd, granted, vacated, and remanded back down to the 4th Circuit for a new decision in light of Bruin. Now, at that time, the case went back down to a 3-judge panel in the 4th Circuit, but then suddenly the en banc panel decided to take the case after it had sat for 13 months, and they took it to essentially give their own review, give their own decision, but they really did that to avoid any pro 2A decision. In essence, they upheld the Maryland rifle ban, finding that these type of rifles, AR-15s, are useful in military service and therefore could be outright restricted. And so they used something known as the military use test, which again does not align with Bruin. Now, as a result of that horrible decision, this Snope case is once again back in front of the Supreme Court, but it's a final merits decision, which is very important because that is something the Supreme Court has said that they've wanted for a long time. They keep rejecting all of the preliminary injunction cases, all these interlocutory challenges, and multiple times they have said or signaled that they actually want a final merits decision. Well, now they finally have one in front of them. Now, like I mentioned, once again, this last Thursday, they held conference once again in Snope, but also Ocean State Tactical. Now, the Ocean State Tactical case, in that challenge, it's essentially a challenge on the preliminary injunction in an interlocutory basis on the state of Rhode Island's restriction on magazines. Now, once again, like I mentioned, this Ocean State Tactical case has been relisted every single time that the Snope case has been as well. Now, you may be asking yourself, what is going on with these relists and why the Supreme Court relisting these cases so many times? What may that indicate? And essentially, why is there 10 plus relists in this case? If they were going to kick it, why have they not just denied them? Now, there's a lot of things we can gather from some of these Supreme Court analytics and tracking some prior cases that have been relisted multiple times. Now, a lot of the analytics and data show us that you want your case to be relisted at least one time. Typically, all of the cases that are granted review by the Supreme Court, a large majority of them, are relisted at least one time. Now, there's also a lot of data that shows that you don't want your challenge to be relisted 2, 3, 4 times, because oftentimes that indicates that your case is going to be denied, and you're probably going to get a dissent order or some sort of a dissent statement in your challenge, and that's why you're getting so many relists, because ultimately it's going to be denied, but someone's going to write a dissent. So where does this data and developments really leave these two cases currently pending in front of the Supreme Court? Well, when you look at the fact that there have been some other challenges that went to conference along with Snope and Ocean State Tactical, like the Gray versus Jennings case, that also dealt, I believe, with the Delaware magazine ban. That one was on an interlocutory basis, preliminary injunction, went to the same conference along with Snope and Ocean State Tactical, but then the Supreme Court denied review to that case. So they kicked it, but then kept the Snope and Ocean State Tactical case. So that was kind of one of the first dominoes that kind of had scratching our heads. And then also recently they denied review to the Antonio case, which also went to conference along with Snope and Ocean State Tactical. The multiple relist could be a product of some dissent potentially being written by some of the justices like Thomas or Alito, who are maybe unhappy with a denial that is coming. However, interestingly, if you look at some of the facts of some of the order lists, when you've had some of those cases denied review, but then they kept Ocean State Tactical and Snope, it could indicate that maybe they are going to grant review to those cases and they're just potentially relisting them multiple times as some sort of placeholder. So if you want to draw a positive conclusion from what's going on with all of these relists, it could mean that maybe they have a heightened interest in these cases and they're potentially just using the relist as a placeholder until they issue something like a per curiam opinion, which is just an outright opinion from the Supreme Court without full briefing and arguments. Something like that could come. Or they're just using the relist as a placeholder until you get an official statement on the docket saying that yes, they've granted review to the case, but maybe they're pushing it out to another term. Now, the other kind of outside chance, which we're going to talk about here, is the fact that maybe they were using the relist as a placeholder and were kind of just stalling out until the California Duncan versus Bonta case, which deals with California's magazine ban. They were using those relists as a placeholder until this case makes it back to them. The Duncan versus Bonta case out of California also is on the final merits of magazine bans. That is a case that was GVR'd prior by the Supreme Court after Bruin was sent back down to the Ninth Circuit, was sent all the way back down to Judge Benitez, who issued a new decision, then made its way back to the en banc panel, and recently the en banc panel issued a decision upholding the magazine ban in California. The Supreme Court could have known that that was kind of looming because that decision there was sitting for almost a year. We had oral arguments all the way back last January, and it had been sitting for a really long time. So the Supreme Court probably knew that that decision was coming very soon. It's already hit, and now we're just waiting for the plaintiffs there to file Supreme Court cert. So it could have been the Supreme Court was simply just holding out a little bit longer until they got a final merits magazine ban case also in front of them. That would be an interesting scenario where you would have a final merits rifle ban case, a final merits magazine ban case, and then also the issue of preliminary injunction in 2A cases that could maybe linger around with the Ocean State Tactical case and resolve that issue as well that a lot of us have been asking for the Supreme Court to address. Now, personally, I don't think that the Supreme Court is going to move on the Snope case or the Ocean State Tactical case until Duncan makes its way back to them and potentially gets relisted for conference. And I would be really interested to see what happens when both Duncan, Snope, and Ocean State Tactical all go to the Supreme Court at the same conference. That would be the one that's more intriguing, but right now we're waiting for the Duncan case to be filed for cert in front of the Supreme Court. So again, there was maybe an outside chance that the Supreme Court was actually waiting for Duncan all along to get back to them, again, on the final merits of a magazine ban, and they're waiting for that before they actually announce that they're going to take review of rifle bans, magazine bans, and all these issues. But as of right now, the Snope case and the Ocean State Tactical case have been relisted once again. They went to conference last Thursday, and then on the order list this following Monday, we're going to get an answer once again. Are they going to relist it, push it out once again, grant or deny? Obviously the best option, the thing that we would all be excited for, would be a grant of review. The worst thing would be an outright denial suddenly after, keeping these lingering for so long. That would be a really bad situation. And a relist would kind of be more status quo. And I think the relist is probably more likely, potentially because they're waiting for Duncan to make its way back to them. So that's what's currently going on with the critical assault weapon and magazine ban challenges. We're going to be keeping our eyes on also seeing when Duncan is filed. And I think that's going to change a lot also in the Supreme Court. So as we get more information, as things develop, I will let you guys know. If you like this video and you'd like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you all for watching. Don't forget to like, comment, and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.